Greeting and respect to all of the participants of this conference. I am Dr. Ahmad Kashfi, from National University of Malaysia, and working in Teleperformance Malaysia with about more than 20 years of experience in reputed international companies. The subject of our discussion in this moment is innocent passage of warship through the Strait of Hormuz, Iran legal position, and international law. During these 4 decades after Iran revolutions, specifically, there has been many conflicts and war in the Persian Gulf, specifically in the Straits of Hormuz and close to it, between Iran and the US and the other superpowers of the world. And this made a lot of concerns about these straits and make it very strategic parts of the world. Iran right of passage through international straits, like the Straits of Hormuz, governed by United Nations Convention on the Law of the Sea. But neither the US and Iran are the party to this treaty. And this is a very critical point that create a very deep ambiguity, legal ambiguity for the Straits of Hormuz. The 4 most significant straits on the world, on the earth, among 125 straits are the Straits of Malacca, the Panama Canal, and the Suez Canal, and the Strait of Hormuz. In the Strait of Hormuz, 21 mile wide in the narrowest point, and all the countries in the Persian Gulf has adopted equidistant boundary between the shore of Iran and Oman, and between the other Persian Gulf countries with Iran. This research strives to clarify long-established legal ambiguity over the passage through the Hormuz Strait. We can see here in the Persian Gulf map, the red line is the equidistance boundary between Iran and the other countries in the Persian Gulf, which is use the method of equidistance, exactly equal area here between Iran territorial waters and the other Arab countries territorial waters, and exactly the line is equidistance here. And the gray line is the territorial waters of Iran, which is 12 neutral miles, considered in even for islands. All islands are considered, these 12 neutral miles are considered for them. This research strives to discuss the following concerns. What are the requirements and description of an innocent passage considering the United Nations Convention on the Law of the Sea 1982? What are the legal rules over the Hormuz Strait? What is the formal and legal position of the Iranian government and the Iranian Navy on the Straits of Hormuz? Do international warships have the right to pass through the territorial waters of Iran and Oman? Can Iran and Oman exercise their sovereignty over international warships passage through the Straits of Hormuz? International law and the United Nations Convention on the Law in 1982. We study in this research and concentrating on the United Nations Convention on the Law of the Sea 1982, Iran has signed it, but has not ratified it. Only Iran is the only signatory party to this convention and treaty. Oman has both signed and ratified it. Iran's reason not to ratify this convention is that in the Strait of Hormuz, where disputes over legal rights exist that may jeopardize national and regional and even global peace and security. The convention is a package deal, not a cafeteria style. The package deal means that the whole convention would be obligatory for all of the members, and no members can select or select the provisions of the treaty and saying that, for example, these provisions are not accepted by us. And it is not selective at all. It is not it is not a cafeteria style. It is completely package style. The whole provisions are come to the force for the whole members of the convention. Article 19, Section 1, the passage of a foreign ship is innocent so long as it is not threatening the peace, good order, and or security of the coastal states. As a whole, the relevant provision of United Nations Convention on the Law of the Sea reflects prevailing customary international law. But for the innocent passage, it is not still proved to be customary international law. What makes the innocent passage non-innocent passage? These actions, the following actions, makes the innocent passage a non-innocent one. Any threat or use of force, any exercise or practice with weapons of any kind, any acts aimed at collecting information threatening the security of the coastal states, any act of the propaganda aimed at affecting the security of the coastal states, the launching, landing, or taking on board of any aircraft, the launching, landing, or taking board of any military device, the loading or unloading of any commodity, currency, or person contrary to customs, fiscal, immigration, and sanitary law and regulations of the coastal states. Any acts of willful and serious pollution contrary to this convention, any fishing activities, the carry out of research or survey activities, any acts aimed at interfering with the system of communication, or any other facilities or installations of the coastal states, any other activities not having a direct bearing on a passage. Iran position in international law. Two main points of Iran is criticizing two main points of United Nations Convention on the Law of the Sea. Innocent passage of warship through territorial waters, the right of transit passage of warship through international straits. Main conflicts between Iran and the world superpowers are these three. The main conflicts are passage of the foreign warships, passage of military aircraft, and submarine transit. Iran legal regime on the Straits of Hormuz. After Iran revolution, all the provisions of the previous governments of Iran in the time of the Shah of Iran combined in one act, and it is called the Marine Area of the Islamic Republic of Iran in the Persian Gulf and the Oman Sea, 1993. The significant parts of these acts we discussed is the prior approval is required for international warships and certain other ships. It is completely contrary to international law that Iran government require prior notice or prior approval before their entrance to the Straits of Hormuz. It also claims excessive criminal and civil jurisdiction within the Iran maritime zone. In Article 8, Iran very generally mentioned just Iran may suspend innocent passage in parts of its territorial sea in protection of national interest and security without clarifying the time, place, and the reason of this suspension. And it is very general, and it opens the hand of Iran to take any action by referring this. And Iran can recognize that for this reason, my security and national interest is endangered by that, for example, warship. And it is not logical, and it is very general. Many articles of the acts are expensive and excessive comparing to equivalent provisions in international law. Iran has repeatedly declared that it would only recognize at the most innocent passage through its 12-mile territorial sea. Interpretation and analysis. The Straits of Hormuz has dual position. One of them is international navigation route. The Straits of Hormuz is an international navigation route, and the other one is Iranian territorial waters. The whole Straits of Hormuz is Iranian and Omani territorial waters. Iran will be responsible for any actions in contrary to customary international law in the Straits of Hormuz. Iran implements transit passage for commercial ships and innocent passage for warships. But international law does not distinguish between commercial ships and warships. Conclusion. The conflicts in the Straits of Hormuz is mainly for the transit of warship of the especially US and England in the Straits of Hormuz during these last 4 decades. Iran and Oman can exercise their sovereignty over the international warship passage through the Straits of Hormuz, unless their actions are against international law or customary international law. As the narrowest points of the Straits of Hormuz is 21 neutral miles, all vessels passing through the straits must traverse and travel the international waters or territorial waters of Iran and Oman. It is completely inevitable for them. They have to pass the territorial water of Iran and Oman. Ratifying United Nations Convention on the Law of the Sea by the US put the US on a stronger footing to challenge Iran's excessive claims in this Straits of Hormuz. Based on Iran legal regime and Act 1993, it seems to be impossible to resolve the conflict between Iran and the other superpowers of the world unless Iran ratified the United Nations Convention on the Law of the Sea. The reason Iran has excessive claims to the straits, which is contrary to international law, is in general is the constant presence of the US and the other superpower warships in the Persian Gulf during these years. Thank you very much for your time. If you have any questions, I am here to reply to you. Many thanks for your kind attention.